All right, so today is Saturday, the 14th of September, 2019. I have not heard anything from the courts or from the Office of State Debt Collection, so I am going to put in a motion to dismiss. And I came across something that might be interesting as I'm looking through the Utah court's motions. They had one under Rule 24A here. It's called intervention of right in this action. So let's switch. I didn't know what that was, so I looked it up. And this is what it says. So this is on Free Dictionary right here. Intervention. Okay, so it is a procedure used in a lawsuit by which the court allows a third person who was not originally a party to the suit to become a party by joining with either the plaintiff or the defendant. Okay? Federal rules recognize two types of intervention: intervention of right and permissive intervention. Now, the reason I'm bringing this up is because if you've been watching and learning and this is starting to sink in, you are not the defendant. Okay? That all capitalized name is the defendant. You are a third party intervener, and you're trying to be the authorized representative of the defendant. So, like I said, I didn't know what intervention of right meant, and so I looked it up, and that kind of sounds like a third party can come in as, regarding, like an example would be the authorized representative of the defendant. Okay? So intervention of right arises when the intervener, the person who seeks to become a party to an existing lawsuit, can satisfactorily show that his or her interest is not adequately represented by the present parties. Well, that kind of sounds like me. And that the interest relates to the subject of the action, and that the disposition of the action might in some way impair his or her ability to protect such interest. Okay, so are you trying to protect your interest? Well, if you're a secured party, if you're the authorized representative making a special appearance as the authorized representative for the defendant, and you have a security interest that's filed with the Secretary of State, and you've done your UCC filings, and you've taken control of your trust, and you have all the documents that you have had notarized and signed and thumbprinted and all that, and you've sent it all off and it's now public record, then you would be a party in interest, correct? So permissive intervention is up to the discretion of the court. It arises when the intervener's claim or defense and the instant suit have a question of law or fact in common. In deciding whether or not to prevent intervention, the court ordinarily balances the needs and interests of the intervener against the potential hardship on the existing parties if such intervention is allowed. The court will determine whether the intervener and the parties to the suit share common issues. I think we do. If the intervener attempts to inject new causes of actions into the pending suit, or his or her request will be denied, since to permit intervention would increase the potential for prejudice and delay in the original action. Okay? An intervener need not argue that he or she will be prejudiced by the judgment if not joined, provided the intervener is able to show that his or her interest will be impaired by the action if he or she is not involved. Okay, so are you the defendant? No, but the state is bankrupt and they're using a real living soul as the surety for that all cap name, correct? Okay, so the defendant is a legal fiction. Okay, you are the authorized representative. You are the secured party. You are the holder in due course. Okay, so if the state is messing with your all cap name that you've taken control of, and they don't have a they're not a party in interest, but through legal orders and garnishments and all these other child support enforcement orders and all this other crap that is legal but not lawful, okay, authorized by some code or statute. Don't you want to try to get involved with that so that you can tell everybody that's involved that, hey, you guys don't have an interest in my property. I have it, and it's already been filed, and any infringement on my rights would be either copyright or legal notice and demand or agreement to the terms and conditions. Okay, this is a good one right here. This is where I liked it. The procedure under which a third party may join an ongoing lawsuit, providing the facts and the law's issue apply to the intervener, which it does because they're using you as a surety, as much as to one of the existing contestants. And it's contestants, see? Because it's all a big show, man. The determination to allow intervention is made by a judge after a petition to intervene and a hearing on the issue. Intervention must take place fairly early in the lawsuit, shortly after a complaint and an answer have been filed, and not just before trial, since that could prejudice one or more parties who have prepared for trial on the basis of the original litigants. Okay, well, that makes sense. Don't throw something in at the end. Intervention is not to be confused with joinder, which involves requiring all parties who have similar claims to join in the same lawsuit to prevent needless repetitious trials based on the same facts. Okay, so legal questions called municipality of actions, blah, blah, blah. So it sounds like you could possibly join or intervene, right, as a third party. So, and then I put this is why I cut and pasted this and put it in my paperwork. So intervention in civil law, the act by which a third party becomes a party in a suit pending between other persons. The intervention is made either to be joined to the plaintiff or to claim the same thing he does or some other thing connected with it, or to join the defendant and with him to oppose the claim of the plaintiff. Okay, well okay. Which is his interest to defeat procedures, blah, blah, blah. In the English ecclesiastical courts, same term is used in the same sense. When a third person, not originally a party to the suit or proceeding, but claiming an interest in the subject matter in dispute, may, in order the better to protect such interest, interpose his claim, which proceeding is termed intervention, right? That sounds like you again. The intervener may come in at any stage of the cause, and even after judgment, if an appeal can be allowed. So you have to do it before judgment, before you go to appeal, all that stuff. So if you got something open, okay, I'm wondering if you can put in a motion to intervene, right? And then put in there that you're, you have a security interest in the defendant. So again, this is my motion to dismiss with affirmative defenses, and then I'm going to put a private judicial notice in there and attach my administrative process that I did against the Office of State Debt Collection. So let's just read this real quick. This is pursuant to, shut up Microsoft, I hate you. Pursuant to Rule 24A of the Utah Rules of Civil Procedure, the authorized representative of the defendant, that would be me, seeks intervention of right in this action in order to assert the affirmative defenses set forth in this motion to dismiss. Authorized representative has an unconditional right to intervene under commercial and common law, and authorized representative claims an interest in the property or transaction which is the subject of this action and is so situated that the disposition of this action may, as a practical matter, impair or impede the authorized representative's interest, which is not adequately represented by any other party. Okay? So I really like the way that sounds. I really like the way that sounds, right? That means time out, everybody. I got to get involved because you guys are trying to take advantage of something that's mine, and nobody here has an interest. except me. So, and then I put in what the intervention is, and then I started my motion to dismiss, which is 12B6, authorize representative of the defendant moves the court for an order dismissing the garnishment and subpoena. The grounds for this motion are that OSDC fails to state a claim upon which relief can be granted, and OSDC has failed to provide proof they are a party in interest, okay? Because they haven't. They haven't produced a judgment. They haven't produced any documents. They have just moved forward. And if you watch my last video, you know what's going on. This motion is supported by the reply that I put in last week, with supporting documents filed and all other pleadings on file with the court in this action. Okay? And then I go through, you know, they didn't do this, so my defense is this. But they didn't do this, so my defense is that. So, okay? And then this is where we're at. So just a quick one. I think that, you know, a motion to intervene, okay, might be something that you want to put in so that you can go in there and say, hey, I'm the only one here that has, you know, an interest in this property, in this defendant. You know, I'm the only one. You know, I'm being used as a surety for this all cap name, so I think I should be involved here. And since I only operate in common law, this case is dismissed.